Good morning. This webinar offers closed captioning. Welcome to the City of Chicago Department of Business Affairs and Consumer Protection's free business education webinar. This webinar is being recorded and will be available at youtube.com/ChicagoBACP. There will be a Q&A session at the end of the presentation. All the BACP webinars are part of the BACP Entrepreneur Certificate Program, which is a free program for anyone interested in starting or growing a business in Chicago. Getting your certificate is as easy as 1, 2, 3. 1, register for the program. 2, attend 6 webinars in 6 months. 3, graduate to get your certificate. Graduating makes you eligible to apply for CIBC Bank's Entrepreneurial Loan Program. Note that you must be already registered for the program to get credit for attending today's webinar. For full details, visit chicago.gov/BACP certificate. Views, information, and opinions expressed during this webinar are those of the presenter and are not the official policy or position of the City of Chicago or BACP. The information mentioned will be posted in the chat box. Today's webinar will be Legal Essentials for Small Businesses. Turning it over.
Good morning, everyone, and happy Friday to those who celebrate. My name is Melissa Picciola, and I'm the Executive Director of Legal Aid for New Entrepreneurs. And I'm here with...
And I'm Sara Ghadiri. I am pro bono counsel at Chapman and Cutler, which is a law firm here in Chicago.
Great. So before we get into any fun stuff, we've got to do a short disclaimer, which is that Sara and I both happen to be lawyers, but unfortunately, we're not able to give legal advice. What we're going to do today is give or tax advice. You definitely don't want to take tax advice from a lawyer, at least in my opinion. This is not legal or tax advice. And if you have a personal situation, you always want to consult with a legal or tax professional about your individual circumstances. So just our disclaimer there, it's legal information, not legal advice. And we don't have time to cover everything in depth. We've got an ambitious agenda this morning. The goal here is to sort of cover everything in a wide breadth and be able to familiarize yourself enough to be able to ask for help on the things that you need help with. Before we get into what we're doing, I just want to make sure you understand what Legal Aid for New Entrepreneurs is. And Sara Ghadiri is the president of the board of directors of Legal Aid for New Entrepreneurs, and I am the executive director. And we are a relatively new nonprofit organization which is dedicated to providing free legal services to low-income small business owners who otherwise can't afford legal support. And our mission is to empower them by providing access to essential services and help them grow their businesses with confidence. We provide a wide variety of services on the transactional side. So we'll talk a little bit more about what that means, but want to make sure that you're aware of who we are and where we come from, and you can see our website there. So what we're going to do today is we're going to do a quick refresher on the U.S. legal system. We're going to talk about areas of law, and then Sara's going to take you through some basic areas of law, which are listed there. And again, we're just going to touch on these topics real quickly, do a little bit of introduction, and then hopefully help you identify some potential legal issues or get familiar with them. So just sort of starting out, it's important to understand a little bit about where things come from and the legal system and sources of law. So generally, there's a difference between state and local law and federal law, right, which are listed there. And there's a difference between civil law and criminal law, right? Criminal law is pretty much anything you can go to jail for, and civil law is everything else. We'll be focusing only on civil law today, and we'll be sort of mixing a little bit of some of the stuff that we're going to be talking about comes from the federal government. That's Congress, that's our president, that's the federal courts. And some of it's going to be based in state law, which is happening in Illinois, in our state, or even local law in the city of Chicago or Cook County. And so when it's important to understand where the law comes from, because you have to understand then what you can do about it, right? If you know where it is, who do you contact if you have an issue with it, or what's going to be the process? Depends on what type of law it is. Is it a federal law, or is it a state law? Or even going further, Is it an executive order, which we often call administrative law, or something administered by an agency? Or is it a court case, something that was decided by a court? So that all sounds like a lot. The good news is that most lawyers can figure that out. And so when you consult with one, they can help you figure out where the source came from to help you understand how to deal with it. So I'm going to go ahead and turn it over to Sara, and she's going to walk us through our first topic, business entities.
All right. So entity formation is one of the most common questions that people ask when they're working on trying to start a business. Some people think about it when they've already started their business and they want to turn it into something else. But it's basically your first step is creating a legal entity to be your business. A lot of people will be like, LLC is it, C Corp is it, this, that, whatever. There's no best form. And entities are created under state law, not federal law. And that's just what Melissa was talking about. So a lot of it depends on where you are or where your customers are going to be. So there's a lot of different types. There's advantages, there's disadvantages. I'm going to try to go through a brief overview. But before I do that, I want to talk about a little bit about the factors to think through. So we've got a big long list here. But these are things that I always recommend that a business owner think through to make sure that they have the right business entity. It costs different amounts to create the entities. Sometimes the documents to create them are more difficult or easier. What's going to happen if somebody passes away or retires? Is there an easy way to continue that business or not? If you want to grow your business, if you want to raise money or expand, if that's in your business plan, you got to be thinking about that in terms of what type of entity you want to create, because some are easier to raise money with than others. The other thing to keep in mind is control, right? Do you want to keep a tight hold on the business? Do you want other people to be able to do business things? And that, again, depends on what kind of thing you're doing and your own personal comfort level. Do you want the public to be able to own it? Do you want to have a public company? Some people think about IPOs, right? Initial public offering. So if you want to sell shares to the public, that's going to be a different conversation than if you want it to be a private company. Another big thing is taxes, right? Melissa talked about the importance of talking to a tax professional, a CPA, sometimes a tax lawyer, depending on what you might need. But thinking about how to be optimized for taxes, right? It's important to pay your taxes. It's important to fund, the government and pay for all the things that taxes need to. But you want to try to maximize the amount that you can keep to put into your business as well. And then also thinking about liability, right? Some people have heard of LLCs, that limited liability, right? That's what that LL stands for. Chapman and Cutler LLP. We are a limited liability partnership. So understanding how that works and how to shield your personal assets just in case your business goes belly up, which we hope never happens. But are there ways to try to do that, to try to limit your own personal liability with respect to your business? And then also, like I talked about, sometimes you have to convert, or you might want to convert for one reason or another. And the ease at which you can convert is also another factor to consider. So I love this chart. It is incredibly overwhelming, and it's my best attempt at trying to summarize everything in one place. And because this is going to be available for folks later to see, you can take a screenshot of it, sort of at your leisure. But this is a really helpful kind of chart that shows some of those factors that I was talking about, right? How easy is it to make? How difficult is it to limit liability? What are the taxes, et cetera? And so these are just things for you to be able to know to ask smart questions, right? At the end of this presentation, my ultimate goal is for you to know when you need to talk to a lawyer or when you need to talk to a tax professional, right? Just because you're seeing this doesn't mean like, oh, shoot, I didn't think about any of this stuff when I made my LLC, like I have to go back to square one. Doesn't necessarily mean that, right? But these are really important things to kind of keep in mind so that you can plan for the future. So a lot of people have heard of a lot of these. So we have limited liability companies. That's the most popular. Sole proprietorships are also really popular. You don't have to do really much of anything because basically under your own name. There's also a couple of different kinds of partnerships here and a couple of different kinds of corporations. And so they all have different pros and cons and stuff like that. So as you're thinking through what makes the most sense for your business. I encourage you to come back to this chart, use it when you're talking to a tax professional or to a lawyer and say, hey, these are the things that are important to me. Can you help me walk through this chart? Okay, so there's people make mistakes, right? That's just like the nature of the beast, right? But I want to try to give you a couple of high level things to try to avoid, to try to make it so that things go smoother for you in the future, right? The number one thing is that if you have a limited liability entity like an LLC, keep your business and your personal funds separate. Okay. You don't want to be treating the company bank account like your own piggy bank where you're just like pulling money from it, kind of like whenever you want, and you're not keeping those separate, right? That is a big no-no, and it can endanger the limited liability protections that you have. Relatedly, corporate formalities are really important. And when I say corporate formalities, that's what I mean is keeping good books and records, keeping your documentation safe, trying to make it in reality that your business and your personal stuff are as far away from each other as possible, right? So because otherwise what's going to happen is a court is going to look at your business and say, well, that business is just a sham. That's not actually something that's real. And so I am just going to basically take it away. All those protections and the limited liability and everything else can go out the window. So I really encourage you to make sure you're keeping really good, detailed records of things money that you're taking out, money you're putting in, capital contributions, all that kind of stuff. The best defense in this case is to keep as much of your documentation in good order as possible. Another thing that if you like Google create an LLC or whatever, like people will talk, will be like, oh, you need to make a Delaware LLC. And that's not always the best choice. Delaware is a really corporate friendly state, and that's why a lot of big companies are Delaware LLCs. And it makes sense if you're a really big company, but it might not make sense if all you're doing is helping folks in Illinois and your majority of your customers are here and stuff like that, because there are extra costs if you have an LLC from another state to what's called domesticate your LLC to be able to have permission to do business in Illinois. If you are not registered as a Illinois LLC, you could be in big trouble. So I highly recommend that you think through whether or not you should have an LLC in another state or not, and talk to a lawyer about it to make sure that you're making a decision that makes sense for you. We already talked about how important it is to talk to a tax preparer. It's really, really, really important. The other thing that I'll recommend is operating agreements, and this varies from state to state. In some states, you don't have to have a partnership agreement, right? So like say, for example, you have a Wisconsin LLC. Wisconsin does not require that you have an operating agreement. It doesn't require that you have a partnership agreement, right? This is starting to change as states try to make laws more friendly for business owners. But if you don't have an operating agreement and something happens, you are stuck with whatever the general state law is on that, and you can't vary stuff. And one of the really powerful things about, for example, LLCs is you have a lot of control about what you can put in that agreement that could vary from state law. So really understand that having an operating agreement is a really good protection just in case something happens. So just because it's not required doesn't mean you shouldn't have one. What I was talking about with the general state law is that's what those default rules are, right? So because and business entities are created under state law, there are laws that exist that cover LLCs and stuff like that if you don't have that agreement. But those might not be what you want or may not be what you intended. The most important thing is to understand how your entity is operating and how you want it to operate to make sure that those things are actually the same. And then the last thing, and this is especially important if you're operating in a big city like Chicago or a big area like Cook County, is you have to understand your regulators. You have to understand registration and you have to understand licensing, right? A lot of LLCs end up getting dissolved because they're not in good standing because they don't file their annual report, right? You have to file an annual report for your LLC, otherwise it's not in good standing. Businesses that aren't in good standing are not allowed to do business, right? And then if you get sued, then this ends up being like a huge of a huge problem, right? So understanding and being in good contact with your regulators, that means at the city level, at the county level, at the state level, those are really, really important so that you don't get tripped up by something. So I'm going to move on next to contract basics. And I like to talk about contracts when I talk to small business owners or startups because contracts are the number one place where I see small businesses get into trouble. And my background is in litigation. So I have been representing companies, banks, financial institutions, et cetera, et cetera. Um, and when you are interacting with other businesses, other institutions, those should all be governed under contract. All right. I don't love to see somebody come in saying, well, I was texting this guy, or like we had this conversation over the phone and he said this and I said that, and now we have a dispute, right? So I want to help you understand how contracts get formed, and I want to help you understand that what you're agreeing to, right? So you can make a contract by a text message. You can do it on the back of a napkin, right? Making a contract in and of itself under the law does not require some like formal, like long document, right? And this is where people can get into trouble, because you want to make sure that both sides agree exactly what's supposed to be happening. And it's really hard to do that by text message or anything else, right? And so I want you all to think through how you're doing business with other people. And it's okay if that's your friend, right? And you say like, oh, but I trust them, But what if like that person ends up in a coma and whatever you said, maybe that person can't talk about because they're in a coma and then they pass away. And then you're like, well, but we had agreed this, and then right, then we're SOL, right? Because there's going to be a lack of evidence in whatever case you would want to bring in court, right?
I just
So
want to say, Sarah, just to jump in, or you lose that phone that has the text messages that has your contract, which has happened more times than I can state when dealing with clients, right? They're like, well, I don't have that phone anymore. So
Exactly. So, like, best practice here is a written contract, right? And written contracts can be kind of scary, right? Because a lot of times they're written in this, like, kind of like undecipherable legalese, and, the lawyer is the only one who understands it. That's a bad contract. A good contract is one that everybody can understand, that everybody understands is straightforward. And there are going to be some things that we call boilerplate, right? And those are and we'll talk a little bit more about it, but those are your venue clauses, your confidentiality clauses, things that don't change from contract to contract, but are really important pieces to have. So when we understand how contracts are formed, how they're performed, and how they're executed, and everybody agrees that about what those should be, then we don't end up in a dispute. So I'm going to give you a roadmap for how to understand how to read a contract. And I cannot emphasize this enough. Anything that you are signing, especially with respect to your business, you should not just be reading once. So most contracts have this kind of like common structure, right? And not all contracts have all of these, and not all of them are missing. Some of them might be missing some, but this is sort of like a comprehensive roadmap for what a contract mostly says, right? And so your needs and what the other person's needs are, and the purpose of the contract, that's going to drive how the structure works. Um, but if you have a contract in front of you, let's say you are working on a services agreement, right? And you agreed to, or you have a widget contract where you agreed to sell X to, Y company. You can use this framework to read through your contract to understand what parts are what, right? And so I'm not going to explain all of these because that would take a long time, but I want to call your attention to a couple of really, really important ones. Okay. And so I want you to always look at the covenants and promises of performance, the condition and breaches in breach and consequences, and then reps and warranties, right? Those are going to be the ones that are going to drive the contract. So covenants and promises, that's where I say, I promise I'm going to sell you 250 widgets, blah, blah, whatever. And the conditions for that, right? That can be like, I'm going to sell it to you on or before X date at or before whatever time, right? And we want to try to be specific, but not so specific that we cause a breach really easily, right? And breach is just when something happens, some problem happens where somebody didn't follow through on their promise, or something that someone represented, which is another kind of promise, right? Saying that I have the authority to enter into this contract, right? And if you don't have the right banking resolution, or you don't have the right documents for your entity, right, and somebody else signs it, that's not you, but maybe you wanted them to have the authorization to do it, well, then maybe you just made that contract not binding, right? So these representations and warranties and stuff like that, those are big parts of a contract that can cause breaches, right? If we promise that these all things are true, that I am licensed to do business in Illinois, that I don't have any regulatory investigations against me from a regulator, right? Those are common representations and warranties. And so understanding what you've promised and what you're promising to do, like continually, are really, really important so that you don't get in trouble with the breach and its consequences. But it's really important to know what happens if somebody breaks this contract, right? What am I promising that I'm going to do? I'm going to try to remediate within 14 days. Is there, a material breach, or is there a non-material breach, right? Is it a breach that goes to the real covenants and promises or performances? Or is it, somebody said it would be delivered at 12 o'clock and it got delivered at 12:02, right? Is that a technical breach or is it a material breach, right? And so all these other ones that are in here have to do with other bits of the contract that are still really important, but I always recommend that people look at those covenants and promises of performance, conditions, breach and consequences, and reps and warranties. The other things might involve like ways you can get out of a contract, right? So force majeure is something that people talked a lot about during COVID, right? Or if there's like civil strife or a civil war or an earthquake or a tsunami, an act of God that people talk about, right? Those are ways where we could say, oh, well, we can't do this contract. And if one of these things happened, it's nobody's fault, right? And we'll figure it out, whatever. So as you're going through and you're trying to understand how these work, try to break your contract into these pieces, and it'll hopefully help you demystify. But if you take this along with you to a meeting with an attorney and say, please explain which of these is which, that attorney will then understand exactly what you want to know and be able to roadmap that contract for you. So the expectation is not at the end of this presentation, you're going to be able to do this yourself, but this hopefully will empower you to ask smart questions when you meet with an attorney. Okay, so we talked a lot about contracts and how they're very confusing and that they're sometimes written only for lawyers and stuff like that. There are some terms in a contract that are always really important to understand. And anytime you have a contract, I would recommend that you can do this regardless of whether or not you're a lawyer. You can look through your contract and see if these things are there, right? And if you don't, if you try and you're like, yeah, I don't know, this is a great time to come and talk to somebody at Lane or go and find an attorney, because these are going to be key to you understanding as a non-lawyer, maybe, what exactly is happening here. So most contracts have definition sections, right? It might have a scope of work, for example, attached as Exhibit A, right? And that might be incorporated in your definition section. Understand, when does your contract start? Is there an automatic renewal? Is there what's called an evergreen clause, which means it renews itself, until somebody gives a proper notice under the contract to cancel? How do payments work? Can you pay by check? Can you pay only by ACH or wire transfer? When are they due? Is there a grace period? When are they overdue? Right? What triggers a breach? How do you terminate? Right? What if you don't have a reason to terminate and you just want to? Versus what if you want to terminate because there's a breach or there's some kind of cause, right? Or let's say something happens and the person had originally ordered 250 widgets and now they need 500 in the same amount of time. Can you modify your contract or amend it? How does that work? What law governs your contract and where do you have to sue, right? There's this idea that the court that hears your dispute should be the one that has quote unquote jurisdiction over this case. But people can pick where they want a case to be heard if there are multiple courts that could have jurisdiction, right? So we might say it has to be in state court in Illinois, or it might be a court sitting in Chicago, right? That could be a state court or a federal court, right? Is there arbitration? If you look at any of these, like anything that you automatically click, like when you're updating your phone or something like that, there might have a mandatory arbitration or dispute procedure in there. Super common to have confidentiality clauses, right? Where you don't tell other people about the material terms of your contract or whatever. Indemnity is where you say, okay, well, if something bad happens, I will pay for for whatever damage happens to you. That happens a lot in insurance contracts. Does your contract provide for attorney's fees? If something goes bad, are you on the hook? Or does your contract say if somebody breaches a contract and they win in court, that the other, the quote unquote bad party, right? Whoever broke the contract has to also pay your attorney's fees, right? And then does it provide for damages? Does it say that the estimation of these damages is too hard, so we agree that any breach of this contract is worth $200,000, right? So those are all things that I want you to think through and understand, even if you aren't going through like the full chart that I had on my last slide. These are all, you should not be signing a contract unless you understand all of these pieces that are in the contract that you're signing. Okay, so there's a couple of other like little bits and bobs that I want you to think about when we're talking about performing contracts, right? And so performance under a contract is, am I doing what I said I would do, right? But what happens if we don't have all those definitions or we don't have bits and bobs? Like, what do I do about the contracts that I already have that maybe aren't as good? Well, there are some legal standby rules that can fill in those gaps, but it might not be in the way that you and the other party wanted or intended. And that's the great thing about contracts is it spells everything out. But the law has developed these other ways to interpret contracts and like put in terms where there aren't terms for people who have them by text message or on a napkin or whatever. So the best way to control for that is to have a good written agreement. And sometimes breaches happen, right? And sometimes there are defenses to that. But don't wait until a breach happens to talk to a lawyer. All right. The best thing you can do is when things start looking like they might not be going good, get a lawyer in right away so that they can talk to you before somebody sues you. If you're talking to a lawyer and you've already got a lawsuit that you're trying to respond to, it's not that it's, too late for forever, but it's going to make it a lot harder and probably more expensive. And then I was talking about before the difference between material breach and technical breach. Courts are going to look for what's called substantial performance. Like, did they pretty much do what they said, right? If you're going to be nitpicky and stuff like that, the court might not care, right? They might say, well, they said 2 o'clock, but it was 2:02 or 2:05 or whatever. And, because it didn't cause like that big of a deal, maybe somebody lost like a little bit of money, but not a ton. Maybe that doesn't matter. Or maybe it was a material breach. And maybe that timing had to work because otherwise this whole system that the other people had set up wouldn't work, right? So there are defenses, there are other things you can do, but I cannot stress enough that too many contracts end up in disputes that shouldn't be there because the contracts that people were using weren't good. The other thing that I want to talk about is what happens when something bad happens, right? And so when we're trying to figure out damages and stuff like that, these are all things that courts can do, and they can force people to do things, or they can calculate damages, or they can fix contracts that have problems, including like rewriting and stuff. But again, by the time this is happening, it's probably a little late. So this is information for you to know so that you're prepared on the front end. I want you to understand these things that could happen if your contract goes bad so that you can help get good contracts to begin with. So there are so many different kinds of contracts, and there's so many different things that I talked about. And some of the stuff I talked about was courts making decisions. Sometimes I talked about, lawyers making decisions about what is in a contract. I want to take a step back really fast and talk about how to know what kind of contract lawyer you need, because there's all different kinds of contracts. And so lawyers are broadly divided into kind of like two camps. There's transactional lawyers, and those are what you think of like deal lawyers. They draft contracts, they review your contracts, they make sure information is protected. They do due diligence to make sure that contracts that are being entered into are based on the facts that people represent, right? And then there's litigation attorneys, and those are the attorneys that go to court, right? So Lane has transactional attorneys that can help you with issues that you might have, right? But Lane doesn't do disputes, right? So we don't have litigation attorneys that take our matters, right? So It's important to know the right kind, because if you come to me and I'm a litigation attorney, right, and you say, hey, I need a contract. Well, yeah, I can review your contract, but I'm reviewing it as somebody who will be litigating it later, right? I might not be thinking about the front end of it, which is like being sensitive to business concerns, trying to make everybody happy, trying to come up with a contract that everybody can agree with. Transactional lawyers have different skill sets than litigation attorneys. And that's not good or bad or right or wrong, right? They're very complementary. I work with transactional lawyers. Transactional lawyers work with me, right? Um, and within these big groups, there are people who have particular expertise, right? And I'm not saying that that a lawyer that advertises that they do everything is like not good at their job, right? There's a lot of people who have a really broad experience. And that's super common, especially in like more rural areas or in smaller firms, or and maybe like in the suburbs or whatever. You might have a firm that can do a bunch of different things. But when you're dealing with highly regulated areas, or you're dealing with things that might be complicated, you might want somebody who has a little bit more of like an expertise, right? You might want a real estate lawyer, or a banking lawyer, or an intellectual property lawyer, or like somebody who deals a lot with the FDA and regulators around food, or employment law or insurance, or whatever it happens to be, right? So when you talk to a lawyer, um, or you're looking for a lawyer, right? The best thing that I can encourage folks to do is to ask questions about somebody's, level of familiarity with these particular things, right? Because if you need a divorce and you go to an IP lawyer, like they're going to be like, well, I don't know how to do that. I can probably refer you to somebody who does, right? And that does, so if you know somebody, or you have somebody who knows somebody else, and you say, well, I need a divorce lawyer, but all I know is this IP lawyer, you can ask them and say, hey, do you know anybody who does XYZ? And lawyers are very happy to refer cases around to make sure that you're getting good service and what you need. But it's really important that you understand what you need so that you can understand what kind of lawyer to ask for or to talk to. When we're talking about new businesses and startups and stuff like that, there are tons of common contracts that you might want or need, and you might not even know what all of these are. Some of these are more relevant for like startups, but some of them might be really relevant to people who are opening businesses together, or how you're gonna figure out who owns what of the company, right? So there might be partnership agreements, employment agreements. If you have employees, there might be NDAs. If you're trying to develop a product and you don't want other people to steal your information, right? You might have operating agreements, or customer agreements, or service agreements, depending on whatever kind of business you have. There might be IP agreements. You might be keeping IP, you might be selling it, you might be getting copyrights, all those types of things. If you have a website, you probably have a privacy policy in terms of use, right? So there's a huge long list of contracts that most businesses will want to have. But it's going to be very important for you to look at what you're doing to make sure that you have all that stuff lined up. And that's not to say you can't do a business without all these agreements. You can, right? But what I'm trying to tell you is that there are best practices and common contracts that can help guard against a lot of problems that might come up in the future. All right. So this is my favorite. You've probably sensed a theme here. After I talk to you about each of these different pieces, I like to talk about common mistakes. Um, Sloppy contract drafting is a huge problem. Sometimes a contract will have like an individual's name instead of the legal entity. You have to make sure that the name of the company is the one that matches the Secretary of State's website. Otherwise, you might have contracted with a non-entity or the wrong person, right? A lot of contracts have schedules and attachments. I talked about scope of work and Exhibit A and those types of things. Read through everything. There's a lot of people have like a master services agreement that they use with a bunch of different people, and then they just attach scope of works to the back of them, right? That says what you're actually going to do, and it has all of the like important pieces of the contract, and those can be complicated to understand, especially like if you're getting loans or anything like that. Those have tons of schedules, so make sure you're reading through all those and understanding what those are, not just the contract itself. If you're reading through a contract and you're looking at the definition section and you're like, well, that looks kind of short, or maybe there's like some vague or ambiguous terms that I don't really understand. If you want a word to have a specific meaning, make sure you define that word. Make sure that everybody understands, right? That doesn't mean you need to define every single word in your contract. Like, what does and mean, right? But like, we might want to define day. Is it business day? Is it weekends? Is it not weekends? Is it federal holidays or not? If I say payment is due in 5 days, well, day can mean lots of different things. So maybe I want to have a definition of day to make sure that everybody understands. Because if I think day means business day and they think day means every day, 5 days means completely different dates, right? So that's one that I use because I think it's really easy to understand how two people could have different understandings of what that means. When you're talking about scope of work and what's going to happen, have timelines, have time frames. Things get delayed, right? So when you're setting due dates or deadlines, make sure that you're estimating, realistically. Don't don't say, well, oh yeah, I'll have this in 7 days. If you don't have it in 7 days, you just blew the contract, right? So you can say within 7 to 10 days, or you can give yourself a range, or you can say, whatever it happens to be. You can define that due date by the thing that happens before it. So be as clear as you can. Um, Contracts that don't specify time and amount of payments are really challenging. You need to explain who makes the payment, how the payment's made, if there's any down payment, what happens if the contract is canceled, what about if you are late, both in paying or in doing what you're supposed to do, right? People end up at the mercy of their contracts all the time because we are missing really important information. If funds need to be in US dollars, right? If they need to be ACH, if they need to be wire transfers, if it needs to be guaranteed funds, that means something different, right? So be really clear about that stuff. The other thing that I see people get caught up in is renewal and termination, especially because a lot of service contracts want things to auto renew. And so if you have something that's auto renewing, it probably says, and you have to give us notice 300 days in advance, right? Or more maybe like 3 months in advance. And so you're like, oh, my contract termination's coming up. I'll just cancel it. Well, many times you can't. So make sure that the renewal and the termination are specific about who gets notice, how contact the person, to whom, all that kind of stuff. If your contract is too legally, right? Like let's say, for example, you go and download something off the internet, which I really highly recommend you don't do. And you're like, wow, this sounds real complicated. And it has all these like wherefore and heretofore and blah, blah, whatever, right? And it sounds really legally. That's awesome. That must be a good contract. False. Unless you fully understand all the legal jargon, write your contract in plain English. If it's too long or it's irrelevant and there's contradictory stuff, everybody's going to have a bad time. And then the last thing, and I kind of talked about this a little bit, is contracts need to be flexible. If you set yourself up to fail, right? If you're setting deadlines that are not realistic, if you're not building some flexibility in, right? Like an opportunity to cure a defect or whatever, you're going to make things difficult. People talk about ironclad contracts. Ironclad contracts actually aren't great because something's going to come up because life happens, right? Having a flexible contract that can account for unforeseen circumstances, and obviously, like if I had, like a crystal ball or like anything that could tell me what the future would be, I wouldn't be delivering this presentation to you. But coming up with a document that can account for unforeseen circumstances as best as you can is going to benefit everybody because our ultimate goal in contracting is to stay out of court. We talked a little bit about signing without authorization or having the wrong signatory. We talked a little bit about don't just download stuff off the internet. You don't know if it's going to work in your jurisdiction. You don't know if that's going to work for your type of business. It's worth having somebody review that contract just to make sure you're not creating more problems. And that's the whole point of organizations like Lane. There are other legal aid organizations as well, depending on wherever it is that you live. But having somebody there to be able to just give this like a little check for you is super valuable. If you're going to be using it, especially as like a repeat contract, like this is going to be your master services agreement, or this is going to be your, contract that you send everybody to do business with, you want to make sure that it's not going to cause you problems. And you're going to want to make sure there's not typos. You're not going to be dealing with problems in like date or price or quantity. And like there are some things that can't be fixed, right? So you don't want to be going too fast. I cannot like tell you how important it is to read things through. Read things before you sign them, read them before you send them out. There's a lot of people who are hurrying and stuff like that. And I get it. Business is really important when you're running a business and you're the only person who's there. Like time is money, blah, blah, whatever. This is something to spend time on. Make sure there aren't typos and stuff like that. And make sure you spend time to understand the contract, right? Saying that you didn't understand it or that, like whatever, that's not going to help you because courts presume that you read it before you signed it, even if you didn't. And if you made a mistake in drafting it and you send it to somebody else and then you say, oh, well, I made that mistake. It's actually supposed to be whatever. The court's going to say, no, you had the opportunity to draft it. Whatever you wrote is what you meant, right? So the party who didn't write it is going to get the benefit of the doubt rather than you. So take your time. And then, like I said, you can have a contract over text message. You could have a contract on a napkin. You can have an oral contract, right? Be careful how you speak. And when you're writing emails to people, say, just to confirm our understanding, this is what we talked about. I'm going to follow this up with a full contract. And our agreement is going to be based on this mutually executed contract. Okay. Next thing I want to talk about is business torts. These are economic torts. A lot of people think about these as loss of profits, loss of reputation, these types of things, right? So it's a wrongful action performed against the business that causes some kind of harm, right? So a tort against a person, right, could be like a wrongful death. It could be like a personal injury claim. Those are things that are not in the realm of criminal law, property law, contract law, that sort of like lumps it all together in this category called torts, right? And so the harms that we're talking about can be all sorts of different things, but it's some kind of economic loss. So there's a bunch of different kinds of them, and they come in different ways. A lot of people are really familiar with the libel, slander, or think they are. But there are other things like tortious interference and restraint of trade, misappropriation, fraudulent representation, commercial disparagement. These are all different types of things that can come up when people are working together, right? And they say, oh, well, don't go work with that supplier. That supplier, is blah, blah, whatever, terrible for XYZ, whatever reason. And if you're intentionally defaming a business's reputation and those things you said aren't true, and you harm that business, that you can be held liable for that, right? If you steal somebody's information, right, don't do that. If you lie to somebody and you say, oh yeah, we can totally do this, and you induce them to sign a contract based on something that's not actually true, you can get in trouble as well, right? So these are just examples. There's more than this, but I tend to um, group those ones together because they're outside of these other buckets, which are breach of fiduciary duty and negligence. And breach of fiduciary duty comes up a lot with directors and shareholders and employees and employers. And maybe this doesn't apply to you, but you should know that if you are an employer and you have employees, there might be duties there, right? You might have certain duties of loyalty or care or good faith that that you could breach, right? You also might have duties if you're on a board of directors, right? Let's say you have a board of directors or you have members of an LLC and you're making decisions and stuff like that. If you're self-dealing, right, that's not allowed. And you can be in trouble for breach of fiduciary duty. Negligence is I think one that most people understand. It's this idea about using ordinary care and caution, and that can exist separately from a fiduciary relationship. But you want to be, if you're negligently running your business and it's causing harm to other people, right? You're negligent in that you didn't have premises liability, right? Let's say, for example, you were supposed to have insurance and you didn't have insurance, right? You ordinary care and caution is something that can come up really easily in like you mopped the floor and didn't put up a sign that says, you got to watch out. Well, ordinarily anybody would put up a sign. If somebody slips and falls, and you don't have the right kind of premises liability insurance, you just put yourself out of business. I like to explain torts as like the best way to stay out of a business tort problem is to keep other people's businesses' names out of your mouth. Don't be petty. Don't get in the middle of other companies' deals. Don't lie. Don't steal. Don't misrepresent. And make sure you understand fiduciary duties, right? Truth is always a defense. And I want to, say like, okay, if somebody is actually telling the truth about a competitor, like that's okay. But if you don't actually know, or somebody's auntie told you, or like your friend said this or whatever, don't spread that information. Don't say that kind of stuff. If you don't know for a fact it's true, you shouldn't be talking about it at all. Running your business in a clean way where you're not being petty or dragging people on social media or anything like that, that's going to make sure that you stay out of trouble. So employment law can be a whole nother presentation because it's so much stuff. And really the takeaway here is that you should have policies if you have employees. There are wage and hour problems, tax problems, discrimination problems, hiring, background checks, pay and leave and sick time. There's so many laws about this, both at the city level, at the county level, at the state level, at the federal level. So employment law can be a real tangle to get in. And so having an employee handbook, having good employee policies, working with somebody who does payroll, a payroll provider or something that can help you comply with all of these stuff and make sure that you're doing the withholding properly, that you are following state and local and federal employment laws, right? So I'm not going to talk too much about this, but employment law is a really, really sticky one that people get in trouble with a lot. So just a couple high level things at the basic level. Illinois is an at-will employment state. People can quit whenever they want for whatever reason. And if you're the company, you can terminate somebody for any reason as long as that's not an illegal reason, right? You can't fire somebody simply for being a member of a protected class, for example. And that's everywhere except Montana. And you can modify that by contract. You can say like, okay, I want to have an employee contract for you to sign. So like a founder agreement or something like that. But keep in mind that the default for most places is at-will employment. There's a lot of common mistakes here. I talked about wage and hour. This is a really specifically important one in Chicago because Chicago and Illinois and federal law are not the same about wage and hour. And there are regulators at each of those levels. And there are rules about minimum wage, even if you're the person who is like a founder of a company, right? Lots of small businesses use independent contractors. Be really careful because if they could be classified as employees, then you could be on the hook for not paying things like unemployment insurance and stuff like that. It's also important to understand what exempt and non-exempt staff means, right? Some people qualify for overtime, some people don't qualify for overtime. And however you're setting your employees up, you have to understand what that means. I talked about the importance of having policies and procedures and all that great stuff. It's an important piece of making sure that you are having a good offense. Because the best defense in this particular circumstance is a good offense. Have an employee handbook. Make sure you understand what it says. This is a big place where a lot of people are using like AI and other things. Keep an eye on it. Make sure that what that's doing is giving you accurate information. Hiring is another area where a lot of people get into trouble. You know, asking somebody, how are you going to do this with all of your kids? You know, you can't ask that question. Oh, are you pregnant? You can't ask that question, right? So there are protected classes. There are different cities have background check laws. You might have heard ban the box legislation that happened in Illinois a little while ago. There are things you can't ask about people's criminal records and stuff like that. And then also, I want to make sure that everybody understands what I-9s and W-4s are, making sure that you have those records and that whatever tax forms you're filling out for your employees are accurate and, make sense. Okay, so we ended a little bit early here, and but I think that's because I saw a lot of questions come in, or I saw a lot of people putting stuff in the chat. So I'm happy to go back and talk about other pieces in a little bit more depth, but maybe this is a good time to pause and go to questions. Is that okay?
Yeah, that's perfect. Thank you. So lots of questions. As far as holding companies, is that why someone would open a DE LLC?
Yeah, so holding companies work a little bit differently and you can do that in a couple of different ways. So you can have like LLC by series. You can also have like a big company that owns multiple LLCs. It's really going to depend again on why. So if you have a Delaware holding company, it might be helpful if you have LLCs that are in different states or whatever, and the holding company is going to be the one that might be subject to liability for some reason. Usually I try to tell people that Delaware companies are helpful if you're going to be doing business in a lot of different states. But if you're not, then sometimes it might not make sense.
Great. How can we get an operating agreement in Illinois?
That's a great question for Melissa.
Oh, sure. I mean, I think the best thing to do is to contact an attorney, right? And Lane may be an option for you if you are someone who considers yourself low income. Then you can definitely apply for our services. If we can't help, we're happy to refer you to other places. You can also contact bar associations, like the Chicago Bar Association has a lawyer referral service that you can contact to try to get help from an attorney. But I would definitely say that, you know, as Sara said earlier, Googling operating agreement is probably not the best way to do that, because an operating agreement really should be specific to what your business is.
Okay, great. Is there any written examples for sample contracts? Is there anywhere you could
So,
suggest?
so I don't like to give samples out because it's, again, like what Melissa was saying, it's so specific to whatever it is you want to be doing. If you're looking for, for help with these things, again, I encourage folks to reach out and see if you qualify for Lane services. Otherwise, we can help refer you to somebody. There are legal databases and other things, and if you ask a lawyer, that you've explained your situation to, can you point me to what this might want, what I might want this to look like, even if I don't want you to pay you to do it, they might be able to provide you with that. But it's not recommended to just pull a sample from somewhere without talking to an attorney first to make sure that what the agreement is saying is what you actually need, right? If you go into a shoe shop and you say, I want a pair of shoes, doesn't really help, right? If somebody could give you anything, I can give you a high heel, I can give you a Birkenstock, I could give you flip-flops, I could give you a boot. Those are all shoes. But without knowing exactly what kind of shoe you need, you might walk out of that store without what is actually going to help you.
Okay, great. Can nonprofits be formed as LLCs?
So nonprofit corporations are different entities, and that's not my area of expertise, to be honest with you. I don't do a lot of work with nonprofits, but not-for-profits are mostly corporations, and that's for like tax and other reasons. So an LLC is a for-profit business entity.
Great, thank you. Which is the one that is allowed to hire and lease or provide services for subsidiaries holding a parent company?
I don't know that I understand that question. Can
Yeah,
you read it one more time?
Yes. Which is the one that is allowed to hire and lease or provide services for its subsidiaries, a holding or parent company?
Oh, so the question is, okay, so holding company and a parent company are two different things. So a holding company can hold things, right? So like real estate. Let's say, for example, a lot of people use holding company for real estate. So we make an LLC. The LLC is the entity that owns like a apartment building, for example, right? Holding companies are designed to hold assets. They can hold IP, they can so patents, for example, they can hold real estate, they can hold all sorts of other things. They can also hold other companies, right? Parent company is just a company that owns another company, right? So let's say, for example, you want to open like a franchise of something, right? So you have an LLC, and that's for you have each individual franchise that you open has its own LLC, and then another company owns all of those, right? And so essentially what you're trying to do is like stack liability, right? Because if you have let's say you have like five places where you run your business out of, if one of them if they're, let's say, for example, somebody slips and falls on one of those, if they're not in separate entities and all held and controlled by a different company, they can get at like the person who's trying to get money can get at any of the locations, right? Or any of your businesses. So let's say, for example, you have a holding company that does one services arm and one like manufacturing arm, right? And something goes bad in the manufacturing arm. If those are not separate, then you have problems with people going against assets, right? If it's all in one company. So A parent company is just a name for something that owns another company. It could be an entity that holds another, it could be a company that owns another company that holds stuff, but the parent company and the holding company usually are two different things. So parent companies often provide services for the companies that they own, right? So they might have like centralized bookkeeping, and like the one of the subsidiaries contracts with the parent company for that, even though like they're kind of the same thing. If you keep them all corporately separate, that's usually where I tend to see um, entities providing services. Holding companies, like the point of it is more to just have a business entity to own something so that it's not an individual that's owning it, right? So we're talking about shielding liability and trying to keep things separated. I hope I answered your question.
Great, thank you. What are you referring to in regards to contract and protected class?
So protected class is usually in the context of discrimination, right? So that can be a class that's protected by race, could be by gender, could be all sorts of different kinds of things. And so the federal and state laws have these protected classes to make sure that people aren't discriminated against, right? So you can't be discriminated against for your age. You can't be discriminated against for whether or not you are a pregnant person. You can't be discriminated against because you have a disability, regardless of whether that disability is something that you can see on the outside or not. So protected classes refers to those classes that are referred to under state and local and sometimes even and so federal, state, and sometimes even local law that protects folks from discrimination.
Okay, great. Can state of Illinois boilerplate contracts be modified? Do you recommend or not recommend questioning state provided boilerplate contracts?
So most of the time they don't let you modify them. And that's to try to keep the state of Illinois from making different agreements with different entities that are providing the same type of service, right? So some contracts may not be able to be modified. And that's then your choice as a business person, whether or not that's a business that you want there, whether that's business that you want or not, right? So government contracts are a whole separate beast that you could do a whole another presentation on, because those have so many different rules in terms of like termination, in terms of renewal, in terms of all sorts of different kinds of things. And different laws actually control federal and state and government contracts than private contracts. So the long and short of it is most of those can't be modified, and there are reasons for it. And the decision about whether or not you want to enter into those contracts is really where the decisioning comes. You can always ask, but most of the time they'll say there's really nothing we can do. And that's just to make sure that the contract management on the governmental entities side is kept as easy and straightforward as possible.
Yeah, and just to add, I think that that's really hammers home Sarah's point earlier about making sure you understand the contract, particularly in a situation where you're not going to be able to modify it, right? You want to make sure you understand each of those clauses and what your responsibilities are under the contract. And the other thing that I would say from a government contracting perspective, what you might be able to modify is your scope of work, right? What you are agreeing to do, not necessarily the boilerplate clauses.
Okay, great. We'll give everyone else another minute to put in their questions. Lots of thank yous, great jobs, great information, very knowledgeable,
Thank you.
right?
Yeah, I didn't even give a little bit of an introduction, which I probably should have. I've been practicing in Illinois for almost 11 years, doing all sorts of kinds of work. And it's been my pleasure for the last 7 years to direct Chapman Cutler's pro bono program. We assist folks through organizations like Lane and provide our services of our attorneys to folks who can't afford it. And that's true of lots of large law firms. But you'll find that most large law firms want you to come through a legal aid organization. And that's the purpose of entities like Lane that exist to understand what you need, help scope, and then help place volunteers that want to help with folks who need the help.
Yes, great. Thank you. So that looks like all the questions today. I want to thank both of our presenters. Thank you so much. Like everyone said, such great information. I want to thank all the attendees. Hoping everyone has a safe and cool weekend. Take care, everyone. Have a great weekend.